always wait for the little voice. Okay, so law. Okay, so similar to international, what I'm going to do in relation to the law is I'm not going to cover off the 50 multiple choice questions because that will gobble up all of our time if we do that. Okay, well, instead, what I will do is I will fire the answers over to you, and you can have a look at them yourselves. Okay, and any questions, you're welcome to reach out to me. Okay, so what I will spend the time doing is I will spend I don't know. There's only 4 questions this time around, whereas I had to kind of cover 7 in the in it, so we have a little bit longer. But so I'm going to cover the 4 questions in the mock exam. Then I'm going to put the mock exam away, and I'm going to give you an idea as to what's in the real exam. But it is not dissimilar to what is in the mock. There is certainly similarities on it. Okay. Righty, so what we have in the mock exam, first question in the mock exam, this is where the time will disappear from us because I have to read the facts of the cases. So question 1 in the mock exam is this. Okay, so Paddy in Dublin wrote to Mary in Cork offering to sell her his Mercedes car for €15,000. On receiving Paddy's offer, Mary telephoned him to say that she would like to accept the offer, but because there was such a large sum of money involved, and because there are 1 or 2 more interested parties, Paddy said he wanted Mary to confirm her acceptance in writing. He said if he received her acceptance the next day, which was Friday, he would go ahead with the sale at €15,000. Mary immediately wrote her acceptance letter and posted it to Paddy in Dublin using the standard post. Paddy received it the following morning, which was Friday at 11 a.m. On Thursday evening, however, Paddy received a better offer from a local guy, and he wrote to Mary to withdraw his offer. This letter missed the last collection, was not received by Mary on Friday morning. Okay, all right. So essentially the question is, okay, go and discuss. Okay. So the first thing that we are going to be covering off in this one, and it's the same, excuse me, in the real exam, is we need to establish, is there a contract? Okay, so that's the first thing we're going to cover off, because there's 4 things required in a contract. There is offer, there is acceptance, there's consideration, and there's intention for legal relations. The first thing you need to cover off are those 4 items. Okay, the second thing you need to look at is there's a as is always the case in law, there's an extra little bit of things to make the case interesting. In this case, it's the postal rule. Okay, so you can discuss the postal rule as the second part of your question, and it's probably important to say there isn't necessarily a right or wrong answer in these. Okay, it's how convincing you can make your arguments. Okay, so you can potentially. I have seen scenarios where people have done exams, and I don't know, maybe there's 10 students and 8 of them have gone one way and then 2 have gone another, but the 2 have gone their own way, have done just as well, if not better, than the other 8. Okay, because they've been able to back up their side of the argument. Okay, so it is not necessarily a right wrong scenario. Okay, it's how convincing can you make your argument. Okay. So first couple of things. Okay, so we need to establish, is there a basic contract? Do we have offer? Do we have acceptance? Do we have consideration? And do we have intention to create legal relations? Okay, and then we go on. If you only get that down, that's the first thing to get down. Okay, is a good explanation as to whether or not you think there are offers or there are acceptance. Okay, so is there an offer? Okay, so Paddy wrote to Mary in Cork offering to sell his Mercedes car for €15,000. Yes, there is an offer. Okay, and it's not an invitation to treat. Okay, it's not an ad in a newspaper. I don't know people with ads in newspapers anymore, but so it's not an ad in a newspaper saying, okay, come one, come all, come buy my Mercedes car for 15,000. He wrote to Mary and said, Mary, would you like to buy my car for €15,000? Okay, so is there an offer? Yes, there is clearly an offer. Okay, is there acceptance? Okay, so if we go back to the facts of the case, it says here, okay, on receiving Paddy's offer, Mary telephoned him to say she would like to accept the offer. Okay, so Mary made a telephone call and said, yes, Paddy, I will buy your car for €15,000. Okay, then you have the additional thing of, okay, Paddy says, well, it's a large amount of money. I would like to, I would like it in writing, because there's 2 or more interested parties. So Mary then confirmed her acceptance in writing. So he said if he received her acceptance by Friday, he would go ahead with the sale at 15,000. Mary immediately wrote out her acceptance letter and posted it to Paddy in Dublin using standard post. Okay, all right. So is there acceptance? Yes, and you could argue that the phone call is acceptance. There was the added thing of I want it in writing and so on, but she fulfilled that as well. She also wrote the letter and posted it. Okay, so is there acceptance? Yes, there is certainly strong evidence of acceptance. So you can even argue that there's no offer if you wish, but you'll need to be convincing. But there is strong evidence of acceptance. Okay. The one that's probably the most straightforward out of the four is there consideration? Okay, it's not a case of Paddy writing to Mary and saying, "Do you want my car?" and there's no discussion of money, and it could potentially be interpreted as a gift. Mary promises €15,000 in return for Paddy's car, so yes, there is consideration. Okay, Mary gets the car, Paddy gets 15,000. So there's no present, there's nothing, nobody's getting anything for free. All right, so there is consideration there. Okay. And then finally, is there intention to create legal relations? So in my introductory lectures, I always give the scenario of kind of, well, what if I kind of talk to somebody about buying my car and it's in a nightclub at 2 o'clock in the morning and we've all had loads of drinks? There's less of a suggestion there. There's intention to create legal relations. There is a strong suggestion here, however, because Paddy, there is the phone call, and Paddy, rather than snap Mary's hand off and say, yes, I accept the offer and I'm going to take it, he said, well, let me see, could I get it in writing? Okay. So very strong suggestion there that there are intention to create legal relations. Okay. So, is there a contract? In my view, like I said, you can convince me otherwise, and you might well successfully convince me otherwise. But in my view, yes, there is a contract in place. Okay. Now, there then are other things we should probably talk about. I mean, those are the basics, and that's kind of the minimum I'd be looking for in terms of the answer. There's other things we probably need to talk about in a minute, but I will pause for a moment, especially since I hear a little bit of a rustling on one of the microphones. Are there any questions in relation to that?
No, okay.
Oh, we're good. Okay, lovely. Okay, so a couple of other things that we can talk about. It is the law. So, I mean, if you're a judge, you will probably end up talking for quite some time in relation to all sorts of things in relation to this case. But a couple of other things that may be worth mentioning. Age of majority. Okay, it's remember the Bobby Byrne case, and the Bobby Byrne was 17, and there was kind of, well, can there be a contract when you're 17? These are, we're talking about a car here, and we're talking about a large amount of money. So it's probably a good chance that these people are over 18, in which case you could have a contract. Now you can put that in and say, well, yeah, maybe you're 17, you could be buying a car, but it's a pretty good chance we're talking about 18-year-olds here. So you might want to make a one line mention of that and then move on. It certainly won't hurt in terms of the marks. Okay. You can potentially mention, okay, well, would Paddy's, would there be less onus on Paddy to go ahead with the sale if it's an invitation to treat? You could potentially mention that, but it's not an invitation to treat. It's clearly a letter to Mary saying, Mary and you alone, do you want to buy my car? So you can go into those kind of discussions. Did I hear another murmur there? Was there a question there? No. No. Okay. And then let me see. And then the other key thing to kind of mention in relation to the case is the postal rule. Okay. All right. So you have, because we are talking about letters here. The letters play a big part in the acceptance, and there's a letter accepting it, and there's also a letter revoking the offer as well. So the key question there is the postal rule, and what the postal rule states is when the letter hits the post box, that's it. Okay. That is then your acceptance or your revocation or whatever. Is in place. So it does mention Mary used standard post. I mean, had Mary used kind of registered post, it obviously may have made it a little bit easier because you'd have a receipt that would say, okay, this is the time that the letter hit the post box. If there was an actual court case about it, you could even get into slightly far-fetched kind of scenarios of kind of, well, is there CCTV of Mary posting the letter, that could be used as part of the evidence to enforce the contract. Whether that would probably be a little bit overkill given the facts of the case, but essentially the rule in terms of the postal rule is when the letter hits the post box, that's when from then on, it doesn't matter if it takes a number of days to be delivered. That's when or maybe a number of days before it's opened at the other end. That's when it becomes binding. Okay. So the key question there is, okay, well, what happened first? Okay, did Mary's letter? It looks like from the facts, in terms of, if you're asking me, I would say it looks like from the facts that Mary's letter was posted before Paddy posted his revocation of it. But that's something you can discuss in your answer. Okay. The key thing I will say, and this would apply to tort as well, which we'll get into, is it can be frustrating when you're reading answers in the exams. Sometimes people are heading one way, okay, and they kind of said, well, yes, there's offer, yes, there's acceptance, yes, there's consideration, yes, there's intention to create legal relations, and as a result, I feel there's no valid contract. And I go, right, you've lost me, because you told me there were all the four things, and then suddenly you're telling me there's no contract. Okay. If you're telling me there's no contract, the chances are at least one of those four has to be flawed. So it'd be a good idea for you to tell me which one. Okay. Exactly the same applies in tort. Okay, there's something has gone wrong in the four requirements in tort. So as a result, you feel the case is a bit wonky. Or you need to say, yeah, there's all four of them, but I'm convinced that the person is 17 and therefore no contract, or I'm convinced the person was not legally, mentally capable of doing the contract and therefore no contract. I think there's clear evidence here that the revocation occurred before the acceptance, therefore no contract. So all I would say is do link. This is where we're learning from I'm giving you guidance in terms of the mistakes of what your predecessors made. Do clearly link. If you're going to say no, there's definitely nothing there, or there definitely is something there, do make sure that there's a thread that gets you there. Or if there is a thread and suddenly something occurs, do give me at least a paragraph to explain why you think suddenly, okay, there's no contract, okay? Because I have actually seen this more than once. I'm saying, okay, so the person is clearly saying this contract, I get to the last line, so therefore there's no contract. Sorry, what? And they lose, I can't give them, and they maybe add a second line, so I know it's not a typo. And I said, well, okay, well, I can't give them a decent score because they've gone one way and then suddenly gone another, without telling me why. So that'd be my guidance in terms of that. Okay, better move on to question 2. But is there anything else on question 1 that anyone wants to ask about?
It's good.
No, we're good. Nice and clear. Lovely. Okay, so if I scoot down, plenty of information there. If I scoot down to question 2. Question 2, thankfully, a little bit shorter in terms of reading. Question 2 is this. So this comes from module 2 and it's company law. Okay. So question 2 is Murphy Limited has indicated in their company constitution that they will renovate houses and apartments and sell them at a market price. Okay, so they're in the renovation business. For 5 years, they continue this undertaking, but then following a review of costs and recent sales across the country, they determine that it is significantly more money to be generated by purchasing land and developing it. Without undertaking any changes to the company constitution, they embark on this new venture, borrow a significant amount of money from Loan Bank, and purchase their first plot of land. Okay, so sounds ominous. All right. Outline the possible consequences of this action for Murphy Limited. Describe how these limitations have been relaxed over time, and what steps Murphy Limited could take to avoid this problem. So essentially, the third bit is essentially the defenses that they could maybe give us. Okay. So there's 3 bits there. So there's a bit to cover in it. Okay, but so first of all, you have the consequences. Okay, so what are the potential consequences? The first one is the transaction may be void. Okay, so depending on who goes to court and who sues whom, the transaction may be void. The court might look at it and say, okay, well, you've gone and you've done this, Murphy Limited. There's nothing in your constitution that says you can go and purchase plots of land and start building on them. So we're throwing this out. You can't do it. Okay, all right. So the transaction might be void, so everybody needs to try to, as best as possible, go back to the way it is. Okay, if that happens fairly quickly, the impact on Murphy Limited will be fairly low, because you're probably just going to have a plot of land that's sitting there, and then they will need to maybe very quickly resell it on to somebody else, or it might have to go back to the original buyer. Okay, and the money sent back and everything unraveled. Okay, but it becomes more difficult if they've started building on it, because you're then talking about knocking stuff down and putting it back. But essentially, that's the first thing that can happen. Okay, the second thing could be that the detrimental contract could be enforced. I mean, the likely scenario here is if a case does take place, chances are it's because Murphy Limited have maybe reneged on their loan, and then Loan Bank want to enforce it. Okay, and then run into problems because they say, well, hang on, Murphy Limited say, well, hang on, sure, we weren't allowed to do it anyway. So you could have a scenario where Loan Bank can enforce the detrimental contract. The courts may have a look at it and say, okay, well, listen, Murphy Limited are only trying to rely on that to get out of paying their debts. So we're going to enforce we as the court are going to enforce the contract anyway. That's the second thing that could happen. And the third thing that could happen is the directors could be subject to injunctions restraining them from making the transaction. So shareholders in the company or other interested parties in the company may well find out about this and say, hang on, we don't like this. It's not in the company constitution. We think it's risky. We're going to lose our money as a result. So they take an injunction against the directors to stop them doing it. Okay, they would need to be quick on it to do it before the transaction goes through, but they could take injunctions to block the transaction. Okay, so those are the three scenarios that could happen. You could have a scenario where the injunctions are taking place to stop them doing it in the first place. You could have a scenario where Lone Bank lose the case and the court rules that they were only trying to get out of it because they were losing money, and then said and forced Murphy Limited to pay the money that they owed to Lone Bank, or the transaction could be declared null and void and say, right, neither of you can do this. Lone Bank should have known this. Murphy Limited know their own constitution, so definitely knew that they couldn't do it, and therefore we're setting it aside. Everything needs to go back to the way it was. Okay. The second part of the question was what relaxations have come in place. So that would come from the Companies Act from 2014. Okay. So once upon a time, you had to clearly say in your company constitution, and well, sorry, it was its predecessor, that you would that these are the things that the company is going to do, but they've been relaxed over time. Okay, so you can include in your company constitution that the directors will drive the company in whatever way they see fit to maximize revenue. Okay, something general like that. That means that if they're selling ice cream, they might say, okay, well, actually, we decided there's no money in ice cream. We're now going to sell windows instead. Okay, and in theory, they can go from one to the other without necessarily making any changes to the company constitution. In the olden days, you wouldn't have been able to do that. But that's the thing that's been relaxed a bit more over time. In the 2014 Act, it's been said that you can rely on your company's constitution, but you can put something a little more general in there, rather than having to be very, very specific as to what was in there. Okay. And then finally, what can be done about it? What are the possible defenses? So the directors could be empowered to change direction of the company. So if it's not in the company constitution, if it says if there's a very strict clause in the company's constitution that says, okay, this is what we are in business to do, you can make a change to the company's constitution and relax it a bit, okay? And say, okay, directors will do whatever they see fit to make the most money possible for Murphy Limited. You could prove that Lone Bank knew that they weren't allowed to do it. Okay, so if Lone Bank are only trying to rely on it because they've lost their shirt, the court, you could Murphy Limited could prove in the case and say, well, hang on, Lone Bank knew all along that we weren't allowed to do this. They have a copy of our company constitution. They clearly read it. And as a result, they knew that we weren't allowed to do this. Okay, so that's another defense that Murphy Limited could use. And then the last one, although this one's a bit trickier, is you could in theory show that the activity wasn't legal in the first place. So if, for argument's sake, there was, I don't know, they were trying to build somewhere that maybe is protected ground and they know they can't build anyway, you could potentially say, well, it wasn't a legal transaction in the first place, and therefore there's no way that it can be enforced. Okay. So there's a lot in that, but those are the three things. If you chose to answer similar questions, those are the three things we're looking for. Any questions on that? How am I doing for time? May not make 12:45, we'll see, but certainly make 1 o'clock anyway. Okay. So third question is on EU law. Okay, and the reading is getting shorter, which is good. So the EU law, the Commission wants to cut greenhouse gas emissions across the EU. They settle on a figure of 33% reduction over a 10-year period. Describe how this proposal would progress through the European Union institutions to become binding on member states. Okay. So there's three stages in such a scenario. Okay, the first one is the consultative stage. Okay, so the Commission is usually the first player. I mean, the Commission drives the general direction that the European Union goes. Okay, so they will be the first player in the process. Okay, so they'll be the ones saying, okay, this is what we want to do. Okay, so what they will then do is they will take individual member states into account. Okay, so a good example of this, if we're talking about greenhouse gas emissions, is a contributing factor in relation to greenhouse gas emissions would be the agricultural sector. Okay, it's not the only one, but it is one. All right, let's say for argument's sake that two countries rely on, let's say 40% of their GDP comes from the agricultural sector, and the next biggest is maybe only 15%. Those two countries would be more adversely affected, assuming they'll have to do something in relation to tackling the emissions on the agricultural side. They will be more severely impacted than countries that maybe where agriculture only accounts maybe 15% of GDP. Okay, so the Commission will take those interests into account. Okay, they may give them a longer time to implement it. They may reduce the reduction in emissions that are required, but at the same time, they will have to take the common good of the entire European Union and not just one or two countries into account. So they will do that. So in terms of what groups they're likely to talk about, given we're talking about greenhouse gases, they will probably talk to business groups who may be sending kind of things up into the atmosphere. They will talk to energy groups who obviously need to power the country. They will talk to farming organizations, okay, for the reasons mentioned above, and they will probably talk to people in the transport business as well, okay, both the motoring side, to put pressure on them to have cleaner emissions, but then also public transport groups, because you may want to increase the capacity there. Okay, so those are the types of people they will be talking to. Okay, that's the first stage. That's the consultative stage. Second one is the review stage. So once the proposal from the Commission is finalized, it'll be sent to the European Parliament and to the Council to be reviewed. Okay, similar to the way that the Dáil Committee, it's similar to the Dáil Committee stage in our own in our own personal kind of domestic law. Okay, if the council and the parliament can agree on everything, then they will go and vote on it, and potentially we have the changes in place. But if they can't, a second reading will take place. There'll be work done on both the parliament and the council of ministers' side to try to kind of change wording or get agreements or concessions or add wording and say, okay, so in order to do this, we will provide X, Y, Z support. So a bit of horse trading goes on during the review stage, and it goes back and forth a number of times. And hopefully, you then end up with a scenario that you've legislation that everybody agrees on that can then be voted on, or you may not. Okay. If you don't, it needs to keep going back until you can. All right. Okay. Then the final bit is the adoptive stage. Okay, so in the adoptive stage, the parliamentary committee votes on the report and maybe makes final amendments to it. When the text has been revised and voted upon, the parliament is deemed to have adopted its position. The process can be repeated one or more times, depending on the type of procedure and whether or not agreement can be reached. Okay, so those are the three steps. You have the consultative stage, the review stage, and then the adoption stage. Those are the three steps that you go through in terms of implementing such a change. So before I go on to tort, which has 4 questions as part of it, is there any questions on that?
No.
Okay, so the last one is tort. So I suppose I'll just repeat what I said at the beginning, just in case I forget to say it again. It's similar to contract. There are 4 requirements that you have in tort in order to prove that somebody has done something to somebody else that ideally would not have happened. Okay, so what are those 4 things? Well, let me see. Before we get to those 4 things, let's read the question. Okay. Declan is a young teenager who's being bullied by another young boy, Rod, in his class at school. Rod has been taking Declan's lunch money, threatening to beat him up if he tells anyone. For months, Rod has been making Declan's life a living hell. Walking home from school one day, Declan notices the local farmer, Tom Brown, has left the gates of a field open, and being naturally curious, he wanders in. The field contains a large barn, and it too is unlocked, so Declan wanders in there to nose around. He searches through some presses and finds a shotgun. The farmer has a license for the shotgun and is a member of the local gamekeeping club, a fact that is well known in the community. The gun is empty, but after a more thorough search in the barn, Declan finds some shells. He hides the gun and the shells in his school bag and heads home. Following day, Declan arrives in the school, sees Rod in the yard, takes out the shotgun, which is already loaded, turns it on Rod and shoots, causing serious injury. Declan also suffers an injury from the kickback from the shotgun. Rod's parents want to bring a negligence action against Tom Brown because they believe that any person who owns a gun should be legally responsible for the injuries caused by the gun. Okay, so 4 different questions here. Just in case I forget to say it, there's 4 questions here. There's only 2 on the real exam. Okay, so you'll have a bit more time to answer them. Okay, now some of these questions kind of they cross over each other a little bit, but you won't have 4 questions to answer. If you do the tort question on the exam, you'll only have 2. Okay, but to start with, quite simply, to bring a successful negligence action, what are Rod's parents required to prove? So 4 things again, similar to contract. You've got 4 things in tort. You need to prove a duty of care. you need to prove a breach of that duty of care, you need to prove damage, and then you need to prove a link between all of it. Okay, so is there a duty of care? Is there a breach of duty? Is there damages? Are there damages? And is there a link between the two? Okay, so in terms of the duty of care, you can start by arguing that. Okay, so is there a duty of care in relation to? I mean, we're talking about a shotgun here. So is there a high duty of care? Something that's naturally very dangerous. Is there a high duty of care there? Yes, it's probably fairly safe. Pretty much from the get-go, because we're dealing with a shotgun, to say yes, there is a duty of care. Okay, you will be absolved if you're the owner of the shotgun. You'll be absolved of any kind of responsibility if the shotgun is potentially in a gun case, which legally it has to be. Is the gun case locked? Is the key not right on top of the gun case, or you can easily just open it? You can deal with those types of things. But is there a duty of care there? Yes, because we're dealing with shotgun, there almost certainly is pretty quickly. Yeah, you can argue the opposite, but in my view, yes. Okay. Is there a breach of the duty? Okay, so that's where the discussion gets a little bit more interesting. Okay, so is there a breach of duty? So let's start with Declan's journey towards kind of getting the shotgun. Okay, so he goes through an unlocked gate. Okay. Now, let's say I jump into the car and I can head to maybe a rural part of the country and I start opening gates. Am I going to find the majority of them are unlocked? I think I probably will. Okay, unless there's a large amount of livestock, and then even then there may well be unlocked anyway. Okay, am I going to find a large number of gates open? Yes, I probably will. Fairly common. I would argue fairly common among places where you have large amounts of fields with gates and so on. So is there a locked, is potentially Tom Brown liable because the gate was unlocked? You could probably argue not, okay, because it's not uncommon to do that. Okay, then you come to a barn. Okay, the barn is unlocked as well. Okay, you maybe have it's now things might be getting a little bit more uncomfortable for Tom Brown. Okay, because you have an unlocked barn. Okay, the shotgun may not be the only dangers are there in the barn. You don't know what else is in the barn, but and you're not told. But you can speculate in your answer. Okay, there's nothing wrong with that. But there is definitely a gun, and there's definitely bullets in there. Okay, there's no mention of a gun case in there. Okay, so is there a requirement to have it in there? Yes, there would be. So we're now getting a little bit more uncomfortable. Is there a breach of duty? You could probably argue there is. Okay, you don't have the gun and the bullets together. That may be a defense, but is it a strong enough defense? In my view, probably not. Okay. Is there damage? Yes, there's clearly damage. Okay, Declan himself suffers an injury in the kickback from the shotgun. Rod definitely suffers an injury. Okay, is there damage? Yeah, similar to consideration in the contract case. That's a pretty quick one. You're probably not going to have to spend too much time arguing that. Okay, is there a link between the two? Yes, I think, and the key thing you need to keep asking. And these are the very key words. If you got a similar one, is but for. Okay, so but for the gate being open, would it have happened? No. But for the barn being unlocked, would it have happened? No. But for the shotgun being there and maybe easily obtainable and the bullets easily obtainable, but for all that, would all of these injuries have happened? No. Okay. So as I said, you're building kind of a fairly strong case against the farmer at this bit. Now, you could argue, I mean, if you jump to the kind of defenses kind of part, could you argue, okay, well, listen, Rod was bullying Declan. Maybe it was reasonable, foreseeable for Rod that Declan would get hold of a shotgun and go and shoot him. It probably wasn't, actually. The likelihood of somebody who's bullying somebody ending up being shot is in Ireland anyway is probably fairly slim. Okay. So could you say, well, it was inevitable it was going to happen? You could, but you'd have a bit of a stretch for the court to believe you. Okay. So those are the types of things that you're looking at. Okay. All right. So examine the criteria for contributing negligence. Are there any relevant cases and so on, previous rulings? So that would be kind of some of the stuff that I've already kind of mentioned. Is, in my view, is there much of a link between Declan's act and Rod's injury? Not a huge amount. Okay, so I wouldn't spend too much time arguing that. I would say no, I don't think there's any significant contributing negligence there. Okay, all right. So Rod's parents believe that Tom Brown, this is the third question. Rod's parents believe that Tom Brown is negligent because he left the gates open and because he left a shotgun in the unlocked barn and because Declan was able to find it. For each of these allegations, determine is there actual causation. Like I said, some of this is crossed over, so we've kind of dealt with some of this already. There's nothing wrong with do look. Maybe unlike myself, do look ahead and kind of say, okay, well, where am I going to put the various bits of information so you don't end up kind of typing it out twice. You can. I won't have any objection if you do a little bit of copying and pasting. Okay, if I see stuff in answering question 1, and then I see it again in question 3, no, that's, as far as I'm concerned, that's fine. Okay, if you're writing it out, then it would definitely be a complete waste of time. But as long as you do kind of copy paste, you're not really losing time on it. Okay, but just quickly going through it, left the gates open. Is that a contributing factor? Could be argued, probably not. He left the unlocked barn. Now you're getting into maybe a little bit more uncomfortable territory. And he left a shotgun in there, knowing there's a shotgun in there. Do you leave your barn unlocked? No, you don't. Okay, all right. So do Rod's parents have maybe a bit of a cause for suing Tom Brown for it? Yes, they do. They're probably not going to get very far suing Declan, given Declan's a minor. Okay, given Declan's a minor, you're probably not going to get very far doing that. You may have a case in criminal law, which we're not dealing with here, but in tort, I'd say it's more likely, if you're the parents, you're going to go after the farmer, okay? Rather than you're going to go after the farmer probably rather than Declan himself, all right? And the last one, can Declan maintain a cause of action against Tom for his injury? Yes, he can, okay? If he's over 18, probably not, okay? But he's under 18, okay? So can he? So based on that, can he, in theory, sue? If you have a successful case on Rod's side in relation to the injury, are you likely to have a successful case in Declan's side? Then yes, you probably are. Okay. All right. Can you just bear with me just one moment? I'm just going to mute this for 1 second. Find the mute area. Okay. Okay, sorry, just bear with me 1 second. Okay, sorry, kid just came in. So let me see then. So okay, so that is those are the 4 points that are covered there. Okay, so those are the type of things we're looking for there. Any questions on that before we get to the real exciting part, which is and I've caught up a bit of time actually. Until we get to the real exciting part, which is next week's exam.
No, I'm good.
No, everybody else good? Yeah. All right. Nice one. Okay. All right. So, okay, nice and straightforward. Okay, so next week's exam. Okay, same format as the mock paper. Okay, you have your 50 questions. Okay, now your 50 questions can come from anywhere in the course. Okay, and there will be some crossover. There will be some that appear on the mock, and they will appear again in the real exam. Now, but do read carefully. Okay, now we're not out to catch you. But that said, maybe just to avoid making it too easy, we may have changed the answers around a little bit, or the word not might have appeared in one of the questions when it's not there in the mock exam. So do take your time and read it carefully, okay? Most people score pretty well on the MCQs, okay? So they are marks that are there for the taking, okay? So do take them, okay? We want to give them to you, okay? So do take them, all right? But most people score well on the MCQs, but they can come from anywhere. So you will need to know, while you might decide to narrow things down for the longer questions, that's fine. You will need to have a good working knowledge as to where to find the answers for all the way from module 1 all the way to the end of module 4, okay? So do have at least a working knowledge of the whole section, even if you decide, for instance, EU law is definitely not for me, and there's no way I'm answering a longer question on it, fine. But do have a good knowledge of the EU law. We do see this every year. There's people who are flying with the answers, and then we hit the EU law questions or something else, and they get maybe 7 or 8 wrong in a row because they clearly haven't looked at that particular section. So I would encourage you to look at every section, okay? In terms of longer questions, so same format again. You've got 4 questions. You need to do 2. Okay. So you will have an hour to get your MCQs done. You will have another hour to get your longer questions done. Okay. There are 4 there. You only have to do 2. You can do 3 or I don't think I ever saw anyone do 4 in law, but if you really want to, you can do 4. But what we will do is we will discard your lowest 2 marks and give you the highest 2. Okay. So, but most people just do the 2. Okay. So what's going to be on it? So question 1 will be on contract. Okay, not too surprising. Okay, all right. So we'll be on contract. So again, we're going to be asking you, there's a different set of facts, but we'll be asking you, is there an offer? Is there acceptance? Is there consideration? And is there intention to create legal relations? So at a bare minimum, give us a good, nice, solid answer in relation to those 4 points. Okay. Okay, it's not enough to just say, okay, well, I feel there's an offer. Yes. Okay. Why do you feel there's an offer, right? Why do you feel there's acceptance? So there may well be something blindingly obvious. Like, I mean, in our example there was 15,000 on offer for the car. So the consideration bit, yeah, I don't expect a full paragraph for you to keep repeating, yes, there's 15,000. As long as you tell me there's 15,000 and 15,000 is the consideration. And on the other side, there's a car. Yeah, that's enough. Okay. So you don't need to go ad nauseum telling me over and over again that that's there. Once is enough. Okay. But chances are 2 or the other 3, there's at least a bit of debate in there. So let's get, do the debate. Okay. All right. In the mock exam, the postal rule came into, was part of the discussion. It's not the postal rule in the main one, but there is something else. There's not, as there always is in law, it's not just the offer acceptance, not just those. There's always a something else. There is a something else in there as well to kind of say, well, maybe there is all 4 of those, but so that section does come into it. There's actually 2 other bits that come into it, actually, now that I think of it. So do have a bit of a go at answering that as well. Okay, if you do your 4 bits for the contract and then you also give me a good explanation. Okay, and again, there's no right wrong answer, but if I feel, yeah, I think this comes into play, or I feel because, or I feel it doesn't come into play because, you're heading for good marks. Okay. All right, so that's question 1. It's on contract law. Okay, the first bit of module 1 is about the court system and all that, and the judges and what's a solicitor, and you don't need to go into any of that. That might come up in the shorter questions, but it's definitely not there in the long ones. All right, okay. Question 2, like in the mock exam, it is on company law. In the mock exam, we did ultra vires, which is okay. Is it within the rules of what the company is allowed to do? It's not ultra vires in this one. Okay, it's to do with, I can narrow it down a bit for you. It's kind of to do with where things have gone wrong financially, that kind of stuff, and what are the options? Okay, so something has gone bad financially. What are the options available? Okay. So that narrows it down quite a bit, but that's the kind of area we're talking about. So we're done with the ultra vires bit. It's not really to do with that. You can bring it in if you feel it's relevant, but you don't need to. Okay. So things have gone wrong financially. What are the options? Okay. That's question 2. Question 3 is on EU law, same as it was in the mock exam. So in the mock exam, we're going to cut the carbon emissions, and how are we going to go about bringing that and making it law? So that's what we covered off in the mock exam. What we've done in the real exam is we've kind of gone to the next stage. Okay, so all right, so let's assume now this is the law, and you have to do your whatever it was, a 30% reduction of carbon emissions, and you got maybe 10 years to do it. So that's all happened. What happens next? Okay, so that narrows down a bit of what we're talking about in terms of EU law for the main exam. All right. Okay. And then question 4, as it was in the mock exam, is indeed about tort. Okay. So tort, you're talking about the breach of duty, the care, the breach of duty, the damage, and the link between the 2. Okay, so you have to cover that at a very minimum. That's what I'm looking for you to cover in that. Okay, what does the reasonable person do? What does the reasonable person not do? Did it happen in this occasion or not? Okay, those are the types of things we're looking to talk about. There's only 4 bits. Sorry, there's only 2 bits of the question, not 4 as there was in the mock exams. Only 2, not 4. Okay. So just need you to answer those 2. And one bit of guidance I will give you, because I know I shared this with somebody during the week, and I can't even remember who it was, but I think I remember who it was. But it is not negligent misstatements. Okay, so you cover that off in your second assignment, and Lottie did a great job there. So that's what we have for your negligent misstatements. We're not going to ask you to repeat it and go through it all again in the exam. It's something else. All right. Okay. But you will definitely have your kind of negligence and your breach of duty, your duty of care, your damage, your link between the two. What does a reasonable man do or not do? You're going to be covering that off in if that is the question you choose to answer. Okay. Let me see any final points. Case law is great. Okay, love seeing case law in there. You're definitely onto a winner if you put the case law in there and you apply it correctly. You're definitely onto a winner there because you're using precedent and saying, okay, well, this is what happened in this case, and this reminds me of that case. So therefore, I'm looking to apply it again. That would be great. It's not the assignments. Okay, the assignments you had 2 weeks maybe to do them. All right. You only have 30 minutes here, so I'm not looking for you to go into the level of detail you did in the assignments. Okay, so don't try and do it. Okay, because you'll run out of time in no time. All right, so do keep in mind it's shorter than the assignments. Okay, but and then if you're doing tort and you're doing contract, at the absolute bare minimum, get your 4 key points down and clearly explain why you think there is whatever it is you're saying there is. And one more time, there's not a right or a wrong answer. You can convince me either way. If I were the judge, and I suppose to a certain extent I am. If I were the judge, you can try and convince me either way. Okay. And very last thing, if there's any assignments still pending, I can still receive them. That's good. Still 1 or 2 are kind of outstanding. I will take them. Probably can take them up to about Thursday. After that, I go into exam mode, and I don't really. I will be clear. I certainly don't have time to accept an assignment next Sunday because is there any chance we can squeeze in, which people have done before. Could I kind of squeeze that in and so on? I'm into exam mode. I correct the stuff, and it goes back to Declan relatively quickly, and Declan takes over from there. And there is a process to it, so the process will be unraveled if I start getting assignments in afterwards, which, to be fair, are well due at this stage. So probably take them up to about Thursday. Maybe I give myself Friday off just to put my feet up, and then Saturday onwards I'm into the kind of correcting mode. So after that, the process takes over, and we don't want to interfere with the process. Okay.
That's grand. Thank you very much, Paul. And thanks everybody. I'll stop the recording now.